Good evening, everyone. I'm Ed Stanton. I'm the independent monitor for this case that we're here on today and the work we're doing with the monitoring team. On the behalf of the monitoring team, I want to welcome each of you on a very cold, crisp Thursday evening. Take it lightly that you're here. And really let them see if you have some other stuff. Okay, again, I want to say thank you again for coming out on this evening. Again, my name is Ed Stanton. We're the independent monitor for the matter of the case of PCL in Tennessee versus the city of Memphis. Before we get started, I want to say first, thank you for coming out, and second, thank you to Pastor Turner, Dr. Turner, for allowing us yet again to use this wonderful facility here for the forum on this evening. As we get started, as many of you know, late last year, Federal District Court Judge John P. McCall held that the city of Memphis had violated a 1978 consent decree called the Kendrick Consent Decree. And two things that most people are aware of the city did wrong was, in that case, sharing personal information with non-law enforcement entities and the use of an imposter account on social media to gather information called political intelligence. And that consent decree, obviously, the Kendrick Consent Decree prohibits this type of activity, particularly surveillance. And as a result, Judge McCall appointed me and my team to help bring the city of Memphis, back into compliance with the Kendrick Consent Decree. So tonight, we want to do a few things. First, we want to explain what exactly the consent decree says. Secondly, what my team and I have been doing over the past year, as well as what's happening with the Kendrick Consent Decree in Memphis and how it compares to other cities and police departments across the country. And to that end, as you can see on your agenda, we put together a series of small groups facilitated by different members of the monitoring team we'll introduce shortly. And they address those same topics, those three topics. And so you'll hear from each member that you see to my right on the monitoring team in small groups, but I wanted to, at this point, just do a brief introduction. For those of you who were here before, I want to also, who were not here before, I want to introduce our monitoring team very briefly. Jim Ledden, who's to my immediate right. Jim serves as the deputy monitor. Jim was a former U.S. attorney in New Orleans for the Eastern District of Louisiana, and brings a wealth of resources and knowledge to the monitoring team. To his right is Rachel Levington-Wallman, and Rachel is a subject matter expert in the social media realm, and so we'll be hearing from her. Next to Rachel is John Hennigan. John Hennigan is our subject matter expert. He is an attorney out of Ridgeland, Mississippi, and we're happy to have him as a part of the team. Again, a subject matter expert in the area of First Amendment. And to John's right is Dr. T. Darren Bowman. Mr. Bowman, Dr. Bowman, that is our police practices expert. Again, brings a wealth of knowledge. He's actually a former police chief from Fort Worth, Texas. And one of the things that I'm talking about on the deep bench, Dr. Bowman is also presently serving on the Baltimore Consent Decree team, as well as Chicago and New Orleans. And so he brings a lot of insight to the work that we're doing, as he has experience from other police departments across the country. To his right is Dave McGriff. Dave is, Mr. McGriff is a former police officer in Washington, D.C., as well as Memphis Police Department officer, having served as Deputy Commissioner of Homeland Security here in the state of Tennessee. And so he is our audit and compliance expert. And at the end of the table, last but not least, is counsel, my colleague, Will Perry, was a partner with the Butler Snow law firm, and he serves as counsel, attorney, and advisor to the monitoring team. Now, let me mention this. The breakout sessions and the rest of the format tonight. And did everyone get a folder? I want to make sure everyone received a folder. Anyone that did not receive a folder, there's a number on that folder. We'll give some other instructions on how that plays out shortly, but I want to make sure that you have a green folder. And if not, there's some hands in the back of some individuals. There's a few people in the back that did not get folders. And so one of the things that we're doing, you see sections 1 down to my left at the bottom of the auditorium, 2 all the way in the back at the top, and you also have station 3. One of the things that we heard from this body, from the community, and particularly from our last session, our first community session, engagement session here in July, was that individuals wanted to get more information in smaller groups as opposed to the wider group session that we had back in July. And so this forum tonight is in direct response to that feedback that, again, many of you and community members that came out to that forum. There may be opportunities for you to ask questions in each of these breakout sessions that we've scheduled. And we've also scheduled, and again, you'll see in your packet the agenda, there is a time and place for question and answers. So if you don't get a chance to post questions, as we will be rotating from these sections, and what you will do, you will remain seated, and then the other individuals from the monitoring team will address the other 2 topics that you didn't get from the first time. So that will be easier to rotate that way, for us to rotate as opposed to each of you rotate. But if for some reason you don't get a chance to ask or post questions in your breakout session, there should be index cards and pins in each of these sessions because we want to get to as many questions and answer as many questions as possible. And so again, we will address those tonight. And those that we do not get to, we will come up with, we will put on our website. We want to make sure we answer and address each of these questions. But for some reason we don't get to your question on this evening, we will post on our website questions and responses to those that we're not able to get to tonight. And our website is memphispdmonitor.com. I'm curious, how many of you all have been on our website? Okay. How many of you have not been on the website? Okay, so I would strongly recommend it when you get a chance, if you could, those of you who have not had a chance to check out or go to the website, memphispdmonitor.com, and all this contact information is inside of the green folder that you have. And a lot of information in there, all of our court filings, upcoming dates, who the monitoring team is, quarterly reports. So I mentioned this at our last forum. Please be advised that this is being streamed live. Again, we're trying to touch as many individuals in the community as possible that perhaps could not be here tonight. And so we're streaming live this forum on this evening. At this point, the agenda calls for representatives to come up from the Memphis Police Department as well as the ACLU. Just one thing, again, lessons learned, and I want to say this because I see a number of you who were here at the first forum back in July. And one of the things that I assured and I promised each of you that there wasn't so much at the forum, but what happened after that. There was individuals that had concerns, wanted to share information that obviously we may not have had the time, and just to give input on how we can make this a more effective and efficient exercise as we, again, engage and inform. And so I want to make sure that those of you all that are here know that the Memphis Police Department, Chief Crow is here tonight, but he will excuse himself because again, we don't want to have in any remote way a chilling effect. We think it's important that representatives of the legal counsel, the city attorney is here, members of the city's legal team, but just again, best practices and lessons learned. This is not any way a reflection of Chief Crow, but it was from what we heard from the community. They would prefer that members of the MPD not be in attendance. And so if and when you see him excuse himself, that is a direct result of, again, good information and comments and remarks from our first forum. So we also have Tom Costelli. Where's Attorney Costelli? Okay. And so Mr. Costelli, Attorney Costelli is counsel for the ACLU of Tennessee. And so I'm going to turn the mic over to Chief Crow Mr. Caselli, and we will, after that, we'll give instructions on going into our breakout groups. And so pay attention on every one of your folders. There should be a number. Just identify the number. You don't have to move right now, but after we hear brief remarks from the city as well as ACLU, we will move in that direction. Chief Crowe.
Thank you, Mr. President. So good evening, everyone. I am Deputy Chief Don Crowe with the Memphis Police Department. I am honored to be here again with you. Since our last public meeting, we have met many times with the monitoring team. We've had many discussions. We've had many phone calls. We look forward to having many more discussions because we do want to get this right. Thank you.
Mr. Caselli. Thank you, Chief Crowe.
Thanks, Mr. Stanton. I'm Tom Castelli with the ACLU Tennessee. Really just wanted to identify myself. I'm here tonight. This is the Monitor and Instinct show, and certainly what I hope the agenda looks to be an informative night for all of you, so ask your questions. But I am here if anyone has any questions about ACLU and our role in this and our role going forward. I do want you to know that the ACLU is in getting regular updates from the monitoring team as well. We're having good conversations and working through this kind of post-litigation process with the monitor and with the city and trying to figure out what we need to be doing going forward. So, but thank everyone. This is a great turnout. I'm thankful for everyone to be here tonight. Hopefully we'll have an informative night. People will be able to get questions answered or give feedback that's valuable to this monitoring team. Thank you.
All right. Thank you, Mr. Caselli. So you identified your numbers on the folders. So we're ready to rotate and move into small groups, sessions. And so, again, if you have a number 1 on your folder, if you would come to this side of the room. If you have a number, I say this side, right behind this placard here saying number 1. If you have a number 2, top back corner is where you'll be. And number 3, bottom to my right, you rotate over. 1, bottom, 2 at the top, and 3 at the bottom as well.
Councilman, how are you? Okay.
Again, 2 is up top. If you have a number 2 on your folder, go to the
What am I signing?
3s are at the bottom right corner.
Oh, am I signing this? Okay. What's your name? You Dominique? Oh, how are you? Number 2. We need all of ours too. Am I supposed to be leaving this here somewhere? Oh, okay.
Mr. Sanford, how are you, sir?
Hello, Mr. McKenzie. How are you? Great to see you. Huh? Oh, yeah, I came yesterday. Hi, go to second. Who else didn't sign? Anybody sign?
Right.
everybody, you got pens and note cards up here in case people have questions. Hi, everybody. My name is Paul Perry. I am a lawyer with the law firm. I'm active David Britt. He is the audit and compliance expert for the team. So I'm going to talk to you about this session, what we've been doing for the past year. There's lots of questions at the first forum, some of the individual meetings that we've been having with people about what is it that you guys do, right? If you open your folder, on the right side of your folder, handout that says section 2. Did everybody get out? Apologies for there's kind of 5 buckets of things we're going to talk about. 5 things that
John, by the way, Finnegan, First Amendment subject matter expert. He and I are going to talk about very, very briefly. What is it you say?
Everybody have that?
Kendrick and Seth.
Remember, one sheet in front of the
1978
another.
but it also consists of a much lengthier,
So the first thing I want you to look at, right, is this document, court ordered sanctions. Okay? So one thing that you didn't understand very well, we probably didn't do a good job of explaining before this litigation happened, right? So litigation is over. ACLU sued the city.
hopefully we did an okay job. We worked very hard on First Amendment.
Everybody with me on that?
So,
Okay.
let's talk
This
about
sanctions order, this is what the court said must happen as a result.
You look at your paperwork here. Number one,
We'll turn
and
the page.
this underpins everything, right?
This
The city and MPD,
That's preamble here, and then there are a number of paragraphs the court has laid out.
political.
Here are each of the things the city must now do to get
They may also not operate or maintain any
So the first number of paragraph there is provided in the
for the
departmental
purpose
regulations.
of engaging.
Gotta provide departmental
So now
regulations.
we need to know what is
Do I
political
see that?
intelligence.
Okay.
According to the court,
I'm gonna come back.
political intelligence is the gathering,
Turn to the second number
collecting,
paragraph on the next page.
the indexing, the filing, the maintenance, the storage, the dissemination, meaning the sharing,
Number 2 is the city will design training,
Publishing.
right? So the city's
of
got the training
information or
officers.
any investigative activity
How to comply with
relating, this is key, relating to any person or any group
turn to the third number paragraph.
association or any other exercise that is protected under the First Amendment. Now,
This one is wording,
I
but
think
all it means is that there's got to be an authorization and documentation process. Anytime there's a criminal investigation that's a protected
cannot be collected by and
specific,
disseminated.
in the consent decree, in section
The important part is, and I think
one of the
John
other,
addressed that,
when you rotate to the first section, there's to go through the
presumes
sections of the
that the
but it's section
activity
G of the
being
consent
enjoyed by
decree
an individual
lays out
person's
the
activity
process
is law.
that the city's got to follow. And we'll talk about that more with criminal investigation. If that investigation be resolved, that makes sense. And so this section requires the city to lay out the process. We, as the monitoring committee, review that process. That makes sense? Yes, no? Okay.
John, I think,
So this is the big one, right? How are they using social media?
John's got a cold, so I think.
Got to have social media policies and guidelines, how to use it, when they can use it, what they can search for, right? So they've got to have social media policies. And then the fifth number paragraph there is a list of assertions, right? So every order begins January 14th, is that right? Every quarter since January 14th, the city has had to file this report. It doesn't even come through the monitoring. So there's every single person.
And so that's what the
That
consent decree is in
Whereas the
every
problem is-
city. It's an agreement
That makes
between
sense.
the
That's going
plaintiffs
direct.
who want to brought the suit
That makes
and
sense.
the city who
No,
wants
not
to
that
sue.
quickly, but
We
they're
talked about the operating deadline portion of the consent decree. Congress on consent decree is based.
all search.
The prohibition against collecting, disseminating, retaining political intelligence.
A comprehensive list. They got
Identify
second
or
police officers,
city and
check
the
devices,
to
every search time
electronically
city
by
by
intercept
its
must
part of
be
the
submitted.
bargain.
Listen to
And
the
the
electronic
plaintiff is
report,
body by
transcribe,
their part of the bargain. Otherwise, they are actually
How
implementing the changes they
any
are
communication
So that's a great question. So one of the things we're talking about is process, how they're gathering that information,
I think
and
it's
then
important
submit
to
that
say,
to the court. So the court
again,
can say, okay, show me this is what they
presupposes, again, this
I
is for
why
I think protection.
Did you talk to BDM?
For example,
Recognizes that lawful communications are protected, and that in the event that there is information that establishes grounds for criminal, a legitimate criminal investigation, then certain political, certain information can be collected, et cetera, but not political intelligence. Yes, sir.
We're looking at.
No, no, the question's to the end.
No, but
We're looking
I
at
do want
just
to
the
come back
crime
to that. I want to
of issues. And so, for example, the Northern we're putting out in year number 7, monitoring the
That right now
Northern
is,
Pacific.
you can see if you were to pull up, some of you probably
We're
were
in
Pacer,
year number 7,
Pacers like
and
that,
that's
where you
because
access
the
federal
topics
guidelines,
for
all of the
monitoring
federal courts.
is just
You
so
can see
are just so
this submission
expensive.
has been made.
We have a
or not
required,
made.
and the question is whether or not the blue light, you want, they want to reach that.
So
The mayor's been putting out propaganda that the blue light cameras would turn off.
Number and the
That all
range
kinds
of
of other
possible
things
covered
would be
by
able
the
to do.
consent decree
And I wondered
are
whether they
very,
could express an
very
opinion
broad.
about that.
That's not
There's
the
two ways
role
here,
in
right?
rugby.
You have access to all
Well,
the
not
records.
just the ACLU, but just like I said, real quick in the process, as a monitor, we are the eyes and ears of the
For a
court.
certain set of legal
We
reasons,
are here to ensure compliance with
information
the
that might
court's
otherwise
order.
be accessible.
And so, we don't pass on the legitimacy of the request. What we do is, we will talk to the city, we'll communicate with ACLU, we'll communicate with MPD, and we will internally formulate what we believe are reasonable positions, share that with the court. Ultimately, it's going to be the court that's going to make, either by agreement, that's going to happen, the court will make the decision. So we would be stepping outside of our role of authority and saying, yes, we think that's the case, or no, we don't. Because remember, in actuality, the actual scenarios that are going to take place out there that require
The
answers
5
are far
paragraphs
more
that I just
complex than the
went through,
hypotheticals that we
all
might
5
do.
of those just constitute one of the things that we do.
So, with that, that's, I've covered the second.
You see a list of
The
penalty
third
references
prohibition
here on that one
the
sheet.
city
I pointed to
and
you.
MPD
Represent-
may not
a policy matrix.
recruit,
I see
solicit,
that. So we
place,
got with the city,
maintain,
a
or
document
employ
that I think at last
any
count,
informant,
70 pages long.
meaning in
It's going
an
back.
undercover capacity, essentially.
Let us see revised regulation
For
138.
the purpose of collecting political intelligence.
To the ACLU.
They may also not infiltrate or pose as a member of any group or organization lawfully exercising its First Amendment rights for the purpose of
So the
political
policy
intelligence.
matrix is kind of the omnibus, all of the
And again, I
policies that
think
we just discussed in
We're
those 5
concerning here, I think it's
parameters.
important
Those are covered in the
to
policy
mention
matrix
that,
that have been sent in.
again, lawful exercise of First Amendment rights.
If you'll go
You have to understand that in situations in which individuals are acting unlawfully,
they're on the filing.
and criminal investigation, legitimate criminal investigation would ensue, there are certain processes that through which MPD and other entities may lawfully conduct, intercept communications and things like that.
Additional draft, working with the city and the ACLU. Judge McCarty has not yet docketed that motion to draft, whenever he does. That makes sense? Second bucket of things the monitoring team has been doing, and I want to get this to you guys.
It's going to have to be determined on a case by
Have
case
on
basis.
RFA.
We don't set
Those
the
are
right
real
line
time
and say,
reports.
well, only misdemeanors and above, et
How
cetera.
do we know? So
That
a lot
is
of the
going to have to be
things by the consent decree, the city will bring to the monitor, hey, we just got this issue, can we do X? Right, and so the monitoring team will
Probably
say,
not
yes, you
going
can
to
do
get
X,
into
but
the
only
mechanics of that. At the end of the day,
no, you can't do X, because that is strictly
is going to the men and women.
Does that make sense?
Okay.
So I asked where the line of criminality was.
But that process also
They're
has
not
been
allowed to collect
ongoing for
intelligence
the past.
unless there's a criminal element involved. So
There
I
was
want to
a
ask
hearing before the
felony
court in
misdemeanors,
August.
basic
Do you all remember that? I know several of your faces were there, where we kind of gave an update to the court about what's been going on. Partway through
At
that
the end of the day,
hearing, there was
Memphis
a
PD,
meeting in
Memphis
chambers with the
PD,
court, and a lot of
every
mention of
day
that in the papers, and there's like a lot
within,
of discussion about that.
their
Part of that
operating
discussion
directives,
rules,
regulations,
the
policies,
city had asked us.
circumstances under which they can legitimately conduct investigations. They will continue to do that. The parameters are going to be determined
That's
through
why
the
that's
consent
part of
decree,
the
through the process that we're going through right now, ultimately by the district court.
So they're not bound by.
Next, number 4, the city and the
They are.
Memphis PD
They
may
are
not do
unless they
anything
get
for the
agreement.
purpose of
They say,
deterring
can we do X? We say no,
exercise
then they can appeal.
of First Amendment rights. Nor may they do anything that reasonably has the effect of deterring the exercise of First Amendment rights. In essence,
The answer to that is every
this
lawyer's
prohibition
favorite answer.
recognizes
Right. Sometimes yes,
that
sometimes.
First
So if
Amendment
it's sensitive,
rights,
right, and if it's
that
ongoing,
it
which
is-
most
it
of
is
these things have been,
inappropriate,
no,
it is
can't.
unconstitutional,
When
it's
the
unlawful
thing is no
to
longer
any
ongoing, then
entity
perhaps.
such
So
as
right now,
Memphis PD or any
there's
department whatsoever
unsealed
interfere with the lawful exercise of
if
constitutional
the court
rights.
thinks that the time is appropriate to do that.
What the consent decree, okay.
I don't know if the women report is right. It is within his.
Yes, you're right there. Okay. Now, John, if you want to go through some examples.
There's nothing set like that, but there is, I don't want to get too much into it, there's a presumption in favor of open access to the courts, and so the court does have to have a rationale for sealing documents and for sealing them beyond a specific period, which has been established.
Those are basically sealed.
For the time being, yes. And so indefinitely, yes, a lot of people say indefinitely, mean forever, no. But I can't tell you when they'll become sealed. If some things are on, here's an example.
What are listed in footnote 5?
Maybe the city has a request that affects something like game day. The specific request might not have been about game day, but it might be something that you do. People coming in from out of town, you've got law enforcement, MPD, you've got law enforcement from other places. It obviously has implications for things that we should discuss in right? So the city may have made a request 3 months ago, right? But it raises the same issues that game day raises. So it might not be appropriate to release to the public that information.
The 4 minutes we have left, because we've had some interim questions, we'll try and accelerate this. I apologize, we have a very short amount of time. The next, number 5, the city and the MPD may not spread damaging, derogatory, false, or anonymous information for the purpose of political intelligence. Now, that means that recording the name, including recording the name, photograph, or license plate numbers of people at unlawful, and rather at lawful meetings or demonstrations for the purpose of maintaining a record. And I think that very, very quickly, I think even though we have 3 more weeks we can cover, John, you want to just mention that one of the examples of which you wanted to talk about?
So RFAs are category 2. Community engagement. This, we've been meeting individually with people. Here, Mr. Stanton.
We have about 2 minutes, and I'm going to rotate. And again, everyone that's in your station, stay where you are, and our speakers and our subject matter expert will rotate to you. So stay where you are.
The city and the MPD may not conduct or supervise any criminal investigation.
Obviously, we've got a report.
that may even incidentally result in the
Last
collection of
category,
political intelligence
here.
or interfere with the exercise of First Amendment rights without, this is important, this is being built now, without the direct written authorization of the police director or his or her, an individual in his or her chain of command authorized.
Okay, now, so that's a broad question, because we're not responsible for.
As you'll see at the bottom of the page.
We're
The
here.
city and the FPD may not maintain personal information about any person unless the information is relevant to a lawful criminal investigation and collected in the course of that investigation. They also cannot share any personal investigation with anyone except another government law enforcement agency that is already engaged in lawful criminal investigation. And finally, the city and MPD may not work with or use any other person or entity to violate the consent decree. What that means is that Memphis PD or the city or any other agency can't depend on or delegate or request or sign to some other law enforcement agency.
I'm going to ask the speakers to wrap it up. We've got about 30 seconds of time to rotate. Again, those of you that have questions, we have cards. Raise your hand if you'd like to have a card to write your question down. So we've got about 15 seconds, and we're going to ask the speakers
One of the things
rotate.
submitted to the court is auditing compliance. That's what they were talking about. That's actually 17 policies. That's a separate document. And that plan covers about 50.
We will look to those cards first, and certainly we will take as many as we can orally.
We're learning as we go.
Actually, if there's a time we'll collect it. So if you finish writing your questions, if you share those with me, we'll try to, because a number of people probably will have the same, similar type of question. Good question. So we're going to collect the cards before we start the question and answer. Hey, Will?
Our job is to
We will stay as long as needed. Will and Dave?
what does the consent decree say? Thank you. What does the consent decree say? Okay. In essence,
One other way this can go afterwards, otherwise.
Okay, hello. I'm standing here. You all hear me? My name is Will Perry. I'm a lawyer.
I wish there was a way we could make this
Subject matter
where everybody could hear
This session answers the question that a lot of people that are been asking. What have you guys been doing for the past year? And so we kind of want to address this.
asking whatever questions you may have about.
Please keep in mind there's a Q&A session.
We have some cards, we'll pass them out, you try to claim the card. Just real quick, I go by 10.
Better? Okay. You've got a folder, please open the folder, and there's a, you've got a little packet that says session 2. Everybody see that? So behind that packet, you've got 2 documents. The first document is kind of a one sheet that tells you what the session is going to cover, right? And the document behind that, it says order memorializing sanctions. You guys see that? Okay, I want you to look at that document right there. Okay? So, I think most people understand now, but I want to make sure I say that the litigation is over, right? The city was sued, it was held to have violated open forum. That's already happened. We're not trying to figure out if the city violated anything. Okay? This sanctions order is what the court said are the consequences. Violate the consent decree. Now this is what happened as well. Does that make sense? Look at that sanctions order. If you look at the front page, there's kind of some preliminary language, and then you'll see a numbered paragraph. Everybody see that numbered paragraph? Yes, everybody with me? Okay. So the first thing the city has to do is revise the regulation that says what political intelligence is. That makes sense? One of the things, of course, you need to make sure that all the police know what political intelligence is. You need to provide this department regulation. Right, see that? Everybody with me? Okay. Turn the page to the second numbered paragraph.
So I wore a lot of hats in my video, and
Got to have training, right? So it's not enough to like revise the policy. You got to train officers. Beat cops, command staff. You've got to train the officers on what it is and what they can do consistent with the consent decree's requirements. Everybody see that? Yeah, again, that came down from the court, right? Go down to the third numbered paragraph, next page. There's a lot of legalese in that paragraph. Here's what it means, right? If the city is going to undertake a criminal investigation, and that criminal investigation might touch on somebody's First Amendment rights, they've got to authorize it and document it a certain way. Does that make sense? One of the other, this section, you already heard from Jim. Okay. So that goes through the individual sections of the consent decree. So that section corresponds to section G, right? Section G of the consent decree says what you can do, how you get authorized to do certain kinds of criminal investigations. Does that make sense? This is where that comes from. This court order says you got to comply with section G. If you're going to do criminal investigation, that potentially involves people's First Amendment rights. You've got to do these steps. You've got to document it. This way you've got to get certain Does that make sense? Everybody with me? Next. Go to the fourth paragraph there. This is the thing that I think most everybody is employed. How are you using social media? What are you doing with social media? Right? There's got to be policies for how you can use social media in a way that is consistent with organizations. Does that make sense? Everybody with me there? It's a good question. So, the draft policies right now are public to a certain extent. Now, I'll get to this, okay? And no, let me count, okay? Fifth number paragraph, the last one there is search terms, okay? That doesn't actually go through the monitoring. So, starting in January, every quarter, the city submits to the court a list of all social media search terms that it uses. And then the court reviews those terms. Whether that's
signed by the judge, and a federal judge signed.
Is that a public filing?
it is a public filing, but it's under seal. And I'm sure you can understand, what searches the city is using when it's got to be kept confidential. The city's doing its job, but we also want to make sure that what the city is doing doesn't repeat the violations that it's already been found guilty of. So the court is reviewing those search terms directly, and if you can come through the monitoring directly. Does that make sense? I went through those 5 paragraphs rather quickly on purpose. Okay, if I turn back to the one sheet, that's one sheet defamatory, right? It says what this section is about. Right, so it says material sanctions order, and it says 5 topics. Okay, the first topic is policy matrix. You all see that? Those 5 paragraphs I just went through, they're all encompassed by the policy matrix. One item covers all of the things that we that I just read. Okay, so since January, the city, our team, ACLU, has been sending back and forth a document, I think at last count, 70 pages that covers all of these policies, revised departmental regulations. What are the training materials going to look like? How frequently will the training be? Who gets trained? When do they get trained?
month
been
less.
sending that
Well,
back and
that's
forth
because of
between the
taking
city
the
and the
cover such a
ACLU
wide
to
range
get it to a place
and
where we
it
feel
takes
that
so
it's consistent
long
with what the consent
for
decree
the
requires. Does that make
by
sense?
the police director.
I saw several hands go here. Mr. Stanton asked for you've been to the monitoring website, pdmonitor.com, PDmonitor.com. If you'll look at monitor reports, the second quarterly report, the policy matrix is an exhibit to that report. Okay, now that report was filed, I think it was filed in August, so there have been some changes since then to the policy matrix. That most recent set of changes has been submitted to the board. The board has not yet adopted it, so we haven't made it. Once the board dockets it,
Is
we will
relevant
dock it
to
to the
lawful
It's
right.
very narrow as opposed to being very broad. And so right now,
That
they
policy
talk
matrix
about
is one of the
how
5 things we've been doing.
personal members from these other consent decrees.
The second thing on the list is
Thanks,
the
I'll
RFA.
just
or whatever.
introduce
Those
myself
are
briefly as
real-time
well.
steps
I'm gonna
by
try
To
to
another
project
governmental law
my
enforcement
people on
agency
both sides. So
that
my name is
because
Rachel
the
Evans.
police department
I
is all
am
founded in
a
criminal
lawyer with an
of the
organization
consent
called
decree.
the
They now have to
Center
request
for
And then
Justice. It's a
number 8, the
nonprofit
city and the
organization
county.
They monitor it.
connected to
Everything
NYU,
happening.
but
Can we
we have an office in
Sometimes the answer is yes,
where I've been
sometimes
for
no,
about
sometimes
8 years.
yes, it
I've been a
no,
lawyer
that
for
is
about
why
17 or 18
that
years.
Memphis
And
PD,
after
that
that
makes sense?
session, I'm in our policy
May-
program called
they
Liberty
make
and
the
National
make the
Security.
ask
So
request
that means that I work
doesn't
on a
like
lot of
another
issues,
law enforcement
particularly
agency, any
related
other
to civil
entity
liberties and
that is not
national
under
security.
consent decree
But
to
especially
do
now,
the
the last
basic
5
law
years or
enforcement.
so,
They
on
can't
issues
partner.
related to
They cannot be
safety,
circumvent
installed
technology,
an
civil rights,
intermediary
and
that
civil
can
liberties. So that's
to such requests.
surveillance
If the city
technology,
doesn't like it,
predictive
then they
policing.
can
And right now, actually, most of my time
Does that
is
make
spent
sense?
specifically on issues related to social media.
I know
So
that the
whether
lawyers
that's
say
by
things.
local and state
So
law enforcement,
here's the best way to
agencies
illustrate
like
that, right? So
FBI,
right now,
CHS,
there
Department of
is,
State, and social
some
media
of you were
monitoring
at
by
the
school
hearing
shootings
in
of
August.
8 to 12
Yeah, in
shootings.
August.
We actually just
So
yesterday
you remember part of
put
that
out a
hearing,
document with about 50
the
other
lawyers
civil
and all the
society
parties kind of went
organizations
into the
about
back and
civil
talked to
rights
the judge privately. That discussion
social
concerned
media
the
monitoring by law.
real-time
So I'm
request.
kind of coming to this
Can we
with
do
the
this?
civil rights
Given
and
the city
civil
an answer,
liberties
they wanted to
lens.
talk to the
And I'm
dog.
on the team as the
That,
subject matter
the information about that has not been made public by
So
the
as
school
T
because it
says,
concerns
this
something that
consent
Well,
decree,
if-
consent
Right.
How about, let me address
determined that that decree is no longer ongoing.
the
It
2018
may
And
be
that's because, and I think you should have it.
In that
in
order,
before the court right now.
Okay.
I think the court
So it
set
says
forth
the
a
provision that
regulation
you
in order is called the show cause.
defendants in the city of
Said
Memphis
to the city
pursuing
and what
engaging
it
in law
would
enforcement
tell me why I
Uh,
should not
and
understand.
the court specifically, the judge,
The city has responded to ACL.
indicated that
consent
an
decree.
understanding that there were going to be
It's built
times
around not
when
interfering
Memphis
with
PD or any police
That
department
we will then
in a lawful investigation could actually
protesting,
find itself searching or collecting information that's legitimate evidence, but also it may actually include your exercise your First Amendment rights, rather than allow this to become a
the city
pretextual
might
thing.
end up
The court
with
indicated
information that's related
know
to
that's going to happen
protected
or
activities.
anticipate that is going to
But it
happen.
sets out a
There needs to be a
process by
record
which that will happen.
There needs to be
It basically
permission
sets
sought
forth sort of a
I can say that
and you have to be
for
limits
the
on the
city
amount of
to
time
kind
you can do that.
of minimum
Those limits can be, those time limits can be extended, but they have to be extended again specific
how many have been
quantified
if there's
and by establishing
for the
court now.
conduct of
Has that ever happened?
So it
That's
doesn't
not big,
say that
well, we haven't been into it that long yet, so
it's a single file that affects
but it sets a lot of protections in place, it sets a baseline, and it kind of
The
sets
third
forth
thing that we've been
procedures
doing
by
over
which
the
that
past
can happen, and kind of standards that
obviously
that
this is
system
the
has
second
to meet.
following we've had. We've also been meeting individually.
So, as folks might know, there have been several hearings during the course of kind of, once the judge issued his order back in October, concluding that the city had violated the consent decree, establishing, thank you, establishing the monitor, and putting some procedures in place. So in that,
Cross-section of the citizen, we want
so
to
in that
know,
order, Judge
we want to get
McCullough,
one way, we want to hear what's
required the
happening,
city
what
to
course
establish
period
a
has been,
process for
what
opening investigations into
facilitated
unlawful
by a
conduct
professional
that
person,
could
who
incidentally
can
result
articulate
in
what's happening
political
better than I can, but all you know is the
political
focus are coming, it's going to be.
also require the city to establish criminal
sense?
guidelines for how we would serve social media.
That's a good question.
Whether it's manual
Yes, yes, ma'am.
Write up what
We're
we've been
using
doing, we
these
tell the courts,
third-party
right?
tools
When the
that
court
by
deems
and large kind of
inappropriate to do so, we make that reporting available to
So since
first
then,
two
there
reports are
have been
made to
2
the
hearings in
Some
front
of
of
the
the
things
judge.
that we
There's
submitted
one
to the
in
court have
April,
not
one
yet
in
been made
August.
public.
The
They are
judge
when
at
they
one
are.
of those hearings, they're all also open hearings, had asked for information about how other police departments across the country
Compliance and auditing is the
dealt
last
with
piece
the
of that.
collection
As far as
and use
the
of social
congressional
media.
auditing and compliance expert,
And
talk
so
to you
that
about
was
that.
something that I had gone back and looked at to really get a
Got
sense
it
of.
electronic Okay, great question.
Covered in the Q&A.
Maybe one of
There
the
are a
couple
lot of
questions
police
that
departments
permeates
that
this, and that is,
social media where
it
they're
hasn't been since
like
pre 1978, because
so
technology was
a lot of them
advancing.
don't have
Because in
any
78,
publicly
you didn't
available
have
policy on
in
how
70,
to
you
do
didn't
that
have
when
social
they
media as you know it today.
I
Because this addresses very basic prohibitions.
I
If,
was
let's say,
able to
there
find
is
maybe 20 or
a
25
protest
police
underway,
departments that
does
did
the
have
consent decree
policies
address
that they
efforts,
posted
perhaps by
online
by
accessible in
MPD,
some other way that had been
to
set out.
electronically
A lot of
interfere
them,
with
honestly,
communications,
were pretty vague.
et
It sort
cetera?
of said
And the
social
answer is
media could be used for
yes.
criminal
In fact,
investigation or
there
situation
are
or something like that.
instances
There were some that were more
that
concrete, more robust. For instance,
in
Austin,
the
Texas,
October 28th
actually
order,
had
in which the court goes into great detail
that sets forth
discussing
ask how
specifically how First Amendment rights
setting up
may be
protections
protected
for social
in
media
terms of
for
use of electronic surveillance, in terms of searches,
setting up
of
protections
infiltrating organizations, et cetera.
classes, so
These
whether
things, these prohibitions no longer specifically relate to sending an undercover operative in.
in circumstances
They now
other than when
address
that's
those
kind of
as a
when I
result of
identify
this great challenge for us. And that's why we have the social media expert riding shotgun side by side with a First Amendment expert who is actually working very, very hard with the court, with MPD, with ACLU to try to, I guess, formulate with the mantra, I guess, try to formulate workable solutions that will protect the First Amendment rights for everyone. And I think probably, this is mostly, in my humble opinion, I think this, the tricky parts of
And so for a
the
couple of the
are going to be
policies, they
played
set
out
out
in the context of social media,
for
online
when they could
communication.
do that, often there was kind of
That's sort of
categorized
most of
pre-approval that
where
was
the
required,
potential
so
for
you
there's
have
a
to go
law.
up to a
And that's because
supervisor.
great teams
There would be
working
some
on
written
those
approval
as we speak.
for that, and it would be, in certain kinds of cases, for instance, you know, where there was reasonable suspicion of criminal activity.
We're gonna be looking at
And there was supervisory.
We're gonna see what the
approval
police department did about those situations. That'll be a big part of our finding.
I was surprised at how few of the policies actually claim the solution for our concerns. I think it's probably not. And some of those are probably read like.
I mean, in terms of actual destruction of information.
In the Facebook letters that they wrote carrying out, they said they removed, I think, 6 accounts.
Not, I personally,
Not just possible
Oh, this is
accounts.
the term.
But they explicitly said that violates their policy to create a fake account. So do they have a separate policy for law enforcement that they allow it? So they're always breaking Facebook policy.
are serious and they are compelling. And that is, and I think that is going to affect,
They have
quite
what's
frankly,
called,
compliance with that
colloquially
is
called
going
a
to
real
affect
name policy.
how
There are no
Memphis
exceptions. So on
PD,
Facebook, they're called
actually,
Facebook
how it
policies,
handles
and there's
information that may be,
You're on there
may
using.
consist of evidence in a criminal case.
Okay,
but
sure.
also
So
they
if
can
you questions, have
run
questions.
the
Sorry, but the city,
Right.
anybody
Our
or city
We actually have, we've had, John talked about property, there were those who were doing
Okay, you got it?
I think
Anybody else? Hey, thanks for your time and attention. We'll be around you afterwards. If you have any questions or want to talk to us individually, we appreciate, you guys being here with our job, being available. So thank you very much. Yes, sir.
Right.
That's part of the
We're
process.
talking about have we had any
That's part of the
destruction
judge
of
order is to put in place a policy regarding.
Non-existent prior
It hasn't been filed.
Well, they don't have it.
Right now,
They should not have publicly working.
I understand that.
Was that maintained?
We have about 1 minute before we go to the next, we rotate over. 1 minute left.
Well, so they are, turn on the
becoming involved, was there a social policy publicly available? Was there a policy?
That they shouldn't. But you listen, it's a great question. These are compelling questions. And I guess
Just as an example, in Memphis, we have multi-agency.
Yes.
Which involves.
Existence of a policy doesn't mean
Yes.
there is a family policy.
Right.
So just know that, and it doesn't mean that the policy.
Well, here was, okay, the question was multi-agency
Anyway, thank you very much.
multiple agencies, not just MPD involved. Or they could represent the all technically they're not. However,
So I guess how are they on that?
under the existing consent, as it stands here, is under section 8,
Evaluate that.
is authorized to solicit or receive or take information or evidence that was collected by any other agency that might violate the terms of the consent. So it is bound by the consent decree, and I think in terms of teaching it, it is stated that operators are responsible to make sure that what it gets is walking your hands. It's not always the end to do.
And I think everyone knows, and they will share about to your point, we have to start out that position, understand and towards
Number 2? All right. What we're going to do is obviously
Okay, yeah, and I tell you,
John's
we'll do our best to project all the way back there.
We're going to try.
And so this is the
If you, I'm sorry, excuse me one second. If you have questions that you've written down, I'm going to come around. If you could just hand them to me. Proceed.
We're going to try to summarize for you what the consent decree says. As simple as that. The consent decree consists of 3 parts, 2 primary parts. Refer to.
So I'm going to try and get a little bit closer.
I think it's.
Well,
That's what we're going to follow.
again, for those of you who didn't hear my intro earlier, my name is T. Bowman. I go by T. You call me T.
It's not this much there, so you can flip to
I expect to get to know everybody on a first name basis, so I'm saying, you know, I have all the years of law enforcement experience. I'm also a deacon at my church. I'm also my dad.
Go to this, it's a great question. I'm with you. Go to the footnote at the bottom of the page. Political intelligence, 27 years at the college of I know it's political intelligence according to the courts. We move on over to means to support gathering,
I wear a lot of hats.
collecting,
And so that's one of the reasons why I have
filing,
involved
maintenance,
in Memphis as well.
storage,
I currently serve
or
on 4
dissemination, means
county
passing on or
boards.
sharing.
I'm in New Orleans, and
Or any other investigation relating to a person's
currently are
beliefs,
11 active
opinions, or other exercise of First
I either
Amendment rights.
serve
And of course,
one of the teams or have been part of the investigative apparatus for most of
with
the
that,
consent
go to
decrees
the
here
second, I guess,
So, just right quick, what happens? Why is there a consent decree? What happens? How does this come about? Well, first, it starts with allegations of violations of the Constitution. The 1994, enacted 1994, allowed what's called 14141, a pattern and practice violation investigations by the U.S. Department of Justice. And so what happens when there are allegations of wrongdoing or constitutional violations of patterns and practice violations, the Department of Justice has pulled together a team to go in and investigate the allegations of wrongdoing at these police departments. Now, not every consent decree has the DOJ as the plaintiff. Here in Memphis, perhaps earlier, the plaintiff that we're dealing with now is ACLU. In Chicago, the state attorney general's office is the plaintiff. The city of Chicago, Chicago Police Department are the defendants. Here, the Memphis Police Department and the city of Memphis are the defendants. Okay, so the investigation goes on. At the end of some point, usually it's months later, there is a findings letter issued from the investigation that says the city of Memphis, the police department, is found to have engaged in this conduct and in these violations. So once the findings letter is issued, then the plaintiff and the defendant come together to discuss those findings and how to remedy or resolve those findings. Well, in every case, the defendant, which is the city and the police department, will say, we don't admit guilt, we don't admit to having done that, but we will agree to implement these reforms in order to address what we found. And so they come to an agreement. That agreement is bound in a document that we call a consent decree. The consent decree is then, once the agreement is made, is signed by a federal judge. And once it's signed by the federal judge, then the court has the authority to enforce the terms of that agreement. So the agreement is between the two parties, but the enforceability of that agreement now becomes upon the federal court. The federal judge signed that agreement. So we know who our federal court and federal judge is for this particular agreement. Now, in every consent decree outside of Memphis, we're looking at a wide range of issues. We look at recruitment, hiring, retention, promotion, supervision, use of force, accountability, staffing. I mean, we're looking at just a wide range of issues and allegations and concerns. And so in the typical consent decree, for example, I'm on the team there, I've been on the monitoring team since day one. We're in year number 7 of that consent decree monitoring process. Why 7 years? Well, it was originally designed to go 4 years, but it's taken this long for the department to come into compliance with the consent decree, with what they agreed to do. And so the court, the judge won't let them out of the consent decree until they come into full and effective compliance with the consent decree. So 7 years in New Orleans, 5 years here, 4 years there, but it takes a long time. So in every other consent decree that I work on, that I'm familiar with, the areas that are being addressed are very broad. The monitoring team then is brought in by the court and the judge to assess the degree to which the plaintiff and the defendant are abiding by their agreement.
Or
Their agreement to do these things
for the purpose of maintaining
to
a
comply
record
with the consent decree. And so that's what the monitoring team does. Now here in Memphis, the Kendrick decree is different from every other consent decree we're working on. Every other consent decree in the country. Whereas all of these other consent decrees are very broad and they address this wide range of topics.
The next one's very important.
Focuses on very narrow,
refers to section G of the
very
consent decree.
narrow,
The city and MPD
very
may
narrow
not
range of
conduct
policy. So Rachel is going to introduce herself and talk about how the consent Kendrick decree is different from all of these other decrees. And also, if you have questions, I'll walk around with cards and written cards, and I'll take
Authorization
cards.
of the police director for his or her designee.
Thank you.
That means that the police department understands going
So
forward.
just to briefly introduce myself a little
And
more
they
fully.
believe that that
My name is
information
Rachel
may
Levinson.
intercept someone otherwise interested in First Amendment rights. They're required to notify their rank, their position, and they're required to do things like organization.
It's an organization that's affiliated with NYU, but we have an office in
The underlying purpose of
we
being
have a
conducted
peer
is
policy program.
investigation.
I'm in the program.
That has, there are time limits to that, which can be extended, John. And if you look at the bottom of the page, that footnote, you can see a little more about it.
Surveillance, privacy, domestic intelligence gathering, things like that. In the last 5 or so years, I've especially been focusing somewhat in the national security realm, but especially issues related to policing, technology, civil rights, and military. So a lot of stuff around surveillance technology, surveillance cameras, license plate readers, cell phone trackers, use of predictive policing technologies. And now, really, most of my work is focused on social media monitoring by state and local law enforcement, by federal agencies, so by large FBI, DHS, Department of State. We're doing a lot of social media use for like music vetting. And increasingly, school districts are doing social media monitoring on campus. We actually get about 50 or 55 other civil society organizations. And just yesterday,
Great question, you stepped on the last one, you're too good. You're good, you got this nailed down, seriously. Okay, I'm gonna jump to the last one.
So I
City and MPD may not work with or use any other person entity to violate the consent decree. And here's what that means is we gotta ask the question down below. Joint investigations, right? Joint gang task force. Everybody's got it. So in that context, Memphis PD may not, number one, use another entity to gather evidence, which it can't do under the consent decree. And it also has a duty to the extent that it can to make sure that when it does receive evidence for information or intelligence, that has not been gathered, maintained, stored, or disseminated in violation of the consent decree. Your question is appropriate. It's actually a good question. It's very good. So I'll go back one, and then I'll say this: the city and MPD may not maintain personal information about any person unless it's relevant to a law enforcement investigation, which is totally legitimate, and it's collected in the course of that investigation. They may also not share, disseminate to another agency any personal information with any person or entity except to another governmental law enforcement agency that itself is already engaged in a criminal investigation. So the context in which personal information may be collected and then shared with other entities requires that it be done in the course of legitimate criminal investigations and with other law enforcement agencies. Those are the, in more or less a nutshell, the 8 key prohibitions we broke down in the most logical way possible. We probably only have a couple minutes. Yes, ma'am.
Necessary to the conduct of a criminal investigation. How is the collection of technical minimized so that it is as little as possible. And then how does it use the legislation to protect against sort of a standard rules. And the consent decree talks about how people can be harassed on the basis of criminal activity.
The question's going to be, can MPD share information, intelligence it gets in what the course of its investigations with FBI?
Now, as I said, I look at this especially from the perspective of thinking about those education. And it was something that the judge spoke to very
Well, and each situation is going to be driven by its own specific facts. So it would be impossible, it would be unfair and impossible for us to say hypothetically, well, yes and no, because the decisions are going to be made in the field by the men and women of Memphis PD, operating within the framework of the policies and procedures that are authorized by the court pursuant to the consent decree. They're going to be done after having received extensive training with counsel, and they are going to be tasked with actually operating within the confines of the consent decree. Right now, there's interaction between the MPD and the monitor's office and the court and ACLU in order to sometimes vet some of these decisions about whether or not they're appropriate going forward.
Yes, sir. Specifically under numbers 5 and 7, so we have cameras all over the city and all around the neighborhoods, and we have license plate readers associated with Skycom as well as some through the city. Does Skycom, these technologies, not run afoul of the consent decree? I mean, or every time I'm entering when that's going to identifiable private information.
It would, for us to just answer that question for you right now would be for us to step beyond the authority that we have as a monitor. Those are legitimate questions. Those are questions that are being discussed, being vetted. A lot is going to have to do with how the purpose for the purpose for which the evidence is being collected, being used. So we're not in a position to be able to say, yes, those Skycom cameras will violate the consent decree, or no, they won't, because again, it's going to require analysis under different circumstances.
And I'm trying to get what a citizen asks about
Even for a lot of the cities that did have publicly available policies, they were pretty big. A lot of them were online, social media, criminal investigations, public safety, finding missing persons. And that was about what that actually means and how to went a couple of policies that were so happens at Austin, Texas, where I'm from. Their policy does set out in some when the department employees are using social media, kind of sets up circumstances. It does still have kind of long functional language. We also use this for the administration of criminal justice enforcement. From my point of view, it's still very broad language that allows a lot of latitude. But the language is still more specific than a lot of others. There are also just a
Remember, the end game is to make certain that the police department is in full compliance with the court consent decree and does not violate anyone's rights, intentionally or unintentionally, but that it does so without degrading its ability to protect citizens. Without I'm not suggesting necessarily that it would. That's a great question. Well, and that's one of the things I mentioned is right. Sometimes the purpose, motivation, and utilization of the evidence is going to be very, very important to the resolution of it. How it's used, how it's maintained. So we can't resolve that question for you, but
I guess in the trial, you saw that the police department, Director Ron in particular, was using unpermitted protests as a reason for a criminal investigation. And y'all mentioned before that this gives us more protection in regards to our First Amendment.
the consent decree
And a
does go
permit
beyond
and the First Amendment, to me, are at odds with each other. So we have a right to assemble, but then we have to pull a permit. So if we don't pull a permit, does that constitute a criminal investigation? If they saw one of us jaywalking across the street at a rally, is that a criminal investigation?
These are great. These are very, very relevant.
Got about 30 seconds, and then we're going to ask that the monitoring team make it back over to the table. 30 seconds, please.
Look, I understand your frustration.
So the question is to briefly or
Basically, it's expressing frustration over us not being here to be able to tell you what does and doesn't violate the consent decree. The problem is, any hypothetical we try to address is going to create the impression that across the board in situations like that, a situation is going to be violent or not a consent decree. Every situation is going to have to stand in its own facts. And so what we're simply trying to do at this point is tell you the citizens what the consent decree in the simplest terms, simply what it prohibits. We're not authorized to say, yes, this fact scenario would be violent with the consent decree. This is not.
We are certainly guidelines in place right now. You have to have policies, but very is it auditing and compliance?
So like in public, for instance, be aware that there is accountability for officers violations.
Is it one wrong as a come up?
Well, you say you all, I mean the department. Here's the deal. First of all, if the monitor, we're the eyes and ears of the court. We're not enforcers. If we receive information that there are violations of the consent decree, we bring this to the court's attention. We make sure the court understands this. We bring everything that's been presented to us.
Okay, again, if we could get the presenters to make their way back to the front, please.
Done, we go.
Okay, we're trying to get to as many of these questions as possible. Give us just about another minute and we will reconvene. All right, thanks for your patience. We have a number of items are coming in. So a couple things that I mentioned earlier. We're going to try to get to as many of these cards as possible. And then I know there are some individuals that would like to have a question, may have a question, and we'll pass the mic around. We want to be mindful of time. And we'll try to get to as many as possible. Those that we do not get to, what I mentioned earlier, if we're not here, we will ensure that we put these on our website, so we'll put the questions and our responses. Obviously, we will not be able to get to all of these, but the monitoring team are going through and we're trying to address as many as possible. Next on the agenda, before we get to that, and before I know there may be individuals who may have to leave, I think the next thing is timeline of what's next, and then questions and answers session. I'm going to be very brief. I'm just going to tell you kind of what's next for those of you that may have to leave. 2 weeks from today, on November 21st, there will be the next hearing before Judge McCullough. Many of you I see here actually showed up. We invited you to show up at the last hearing before Federal District Court Judge McCullough at the federal courthouse. We welcome you and invite you to attend that hearing. At that point, we'll be giving the court a status update of where things stand, what we've done as the monitoring team. For many of you who were there, you recall Judge McCullough is very engaged. In fact, he calls some of you by name and invited you to stand up and share your comments, and also invited you to share your comments with the monitoring team. Those things that he did not have the time to listen and hear everything, he said share with the monitoring team. We received that information, and thanks for sharing that. That's with the court. A number of individuals sent things in writing. Remember, at least there was one video. All of that is in the hands of the court. So Judge McCullough has made it very clear to me as the monitoring team that he wants as much transparency as possible, engagement with the community, and for us to make sure that you are informed. And he wants to hear from you. So again, I've talked to a number of you tonight that had some other suggestions. Continue to call on me and my team. I don't know that there's anyone that's reached out to us that we have not responded, whether in person, over the phone, whatever you're comfortable with. So that's the next kind of important date to keep in mind. Secondly, between now and the 21st, we will be filing online with the court our next report, a quarter 3 report. Again, an update of everything that we've done. You'll find attachments, things that we have worked on with the city, protocols, procedures, and items that we've suggested to the court. The ACLU has been a part of the process. Mr. Castelli will tell you the court wants to make sure that as we're going through this process that the ACLU is not left out for comments and their insights on our recommendations. Thirdly, between now and the hearing, there may be a potential release of August 27th hearing. Many of you all may recall, whether you were there or not, it was printed in the media, that there was a in-camera meeting with the court only. So we were at the hearing on August 27th, and there was an issue that came up, and we were in the judge's chambers. There has been, it's a question of whether or not that transcript will be unsealed, and very possibly there will be a ruling on that, the potential release of the transcript from what was said in the judge's chambers back on August 27th during the hearing that we had that was public. Next, resolution to the city seal motion to modify the consent decree. And looking at a number of the questions, there are questions about what's in that motion, the position that the city has taken. But again, that is with the court, and there may be a resolution in the near future. Obviously, that's left to Judge McCullough, but that has been briefed, and many of you have seen that in the media, that has been filed again under seal, so the court is for the court's eyes only and the parties. But it's possible that the court will rule on a pending seal motion to modify the consent decree. One of the ways, and we hear over and over again, how can we get involved? One of the first things that we heard in July, a resounding matter, is we want to have, and I said we, the laypersons, members of the community, we want to have more of a part, whether that's serving on the monitoring team. And in fact, I don't know if you have, those of you that have your folders, but in your folders, I think it's on the left-hand side, you'll find something that says, I just want to take a moment, and it says second quarterly report, community input, 3 pages. But I think it's worth noting, because I want to make sure that everyone here understands that your comments, suggestions, and insights are not falling on deaf ears. And so with our last quarterly report, we shared these items. You see A through, looks like I. But these are items that when we just pulled a copy of, just in a couple pages from what we shared with the court. But this is what we shared in writing with the court on August the 27th of this year. What I addressed the court and said, and the first thing that you will see is what we heard from the community at the last forum and then follow-up meetings subsequent to our last forum in July, the first forum. And it says, I'll just read, A, the monitoring team should be broadened to include one or more, quote, lay community members. This broadening would help establish trust between the monitoring team and the community and facilitate better communications between the two. A lot of you may say, well, and we're very excited about the turnout tonight, but you say, well, why are we doing the small groups, and why are we kind of moving around, why are we doing it a little differently? One of the things you'll see in F, the monitoring team should do a better job of discussing the subjects and should not overly rely on referring people, and you recall, those of you who were in July, a number of times I said, just go to the website, and we had some really good insights. Some people said, what if I don't have access to the website? Or if I see it, how can I print these materials? And so that's why we have a packet of information. Again, all of these things, and I won't go through all of them, but hard copies, hard copies of documents discussed in community forums. That is, again, having a listening ear, but all of these items, A through I, have been submitted to the court, and the last thing you see is that we said to the court, the monitoring team commend these recommendations to the court's discretion. So again, we welcome your input. It's not falling on deaf ears. Obviously, the judge will be the final arbiter, whether someone else joins the monitoring team, if there's an advisory committee. Again, that's not our call, but it is important for us to share with Judge McCullough, and he wants to hear, again, for those of you that were at the last court hearing, hear from you. So that I just wanted to kind of give insight as to even the format tonight and the agenda, sharing that. We shared the agenda on our website before we got here. These were all recommendations that we heard from many of you throughout the community of how we can make this better. And quite frankly, this is a good thing. We're bursting at the seams. I think the next time We will most likely be in a different venue. It's time to move around. We want to make sure we're somewhere accessible to the community, and also, in the acoustics and some other things that I think we can work on. That's a good problem to have when you have the number of people who turn out. So, again, please share your thoughts, even with a venue. If you think there's a better place. We were looking at, I will tell you, the Ben Hooks Library is triple booked for several, the National Civil Rights Museum, a number of places that we looked in, and again, fortunately, the Student Boulevard was able to accommodate us when others could not. Last but not least, things that are coming up, focus groups. A number of these questions that we'll get to, you say, well, how can I get involved? Focus groups, that will be coming up in the upcoming weeks. We've shared that with many of you. If you're interested in serving on a focus group, and that is sharing, there are a number of questions for those of you who know, but we talk about focus groups and items and getting the sentiments of the entire community. The best way to have the best focus group is getting a broad section of the community. And so we welcome you, let us know. You can contact us. Many of you already raised your hand and have said, I want to be a part of those focus groups. When you say, I want to be a part of this, how can I play a part? Again, the focus group process. So we're looking at, in the upcoming weeks, I know we have the holidays, but we've retained a moderator or facilitator who's in this space, who's worked in this space. We're very excited that her team will be on board. But again, we welcome you to participate in the upcoming focus groups. Last but not least, implementation. We'll talk about next steps. Implementation of our audit and compliance plan. And you heard from Mr. McGriff and Mr. Peary this evening in one of the breakout sessions. But again, holding accountable. You can have a lot of policies and procedures and training, but who's watching and who is documenting and who is doing the spot checking to ensure that everything that's put in writing and everything that is adopted, that the court adopts that we've recommended, that it is in fact being adhered to. And so compliance and auditing plan, we propose that it will start at the first of the year again to ensure ultimate compliance. I know monitoring team members, I don't know, we've got a number of different cards. I'll pass it over. I have a few here. And again, we will get to as many as possible. I know there are a number of individuals may want to ask a question over the mic, and we'll ask again that you be respectful of time. And those that we do not get to, we will put them on our website, questions and answers. And as you can imagine, some of these are redundant, so I think we can cover quite a few with one response.
One of the things that I think we all noticed pretty glaring is when we're interacting with you all in small groups, all of your questions were relevant, really, really good. The first one I'm looking at here mirrors a couple of those questions, and it's very, very relevant. Are there any groups within or affiliated with Memphis PD that are exempt from the monitor, and why? And I take that to mean exempt from the consent decree, right? First of all, the answer is that there are no groups that exist within or as part of the Memphis Police Department that are not, that operate outside the jurisdiction and the requirements of and the prohibition of the consent decree. Boom, end of story. Now, the question of the tougher part is there anything, or are there any affiliated with Memphis PD that are exempt? Remember that, and this is very, very important, entities such as other law enforcement agencies, federal, state, local, that are not MPD are not covered by the consent decree. However, the consent decree itself, specifically, the last portion of the consent decree, in essence, says the city and MPD may not work with or use any other person or entity to violate the consent decree. What that means is that when MPD is dealing with, whether it's a task force or whatever, another agency that is not under the consent decree, Memphis PD cannot rely on that agency to collect evidence or what could be political intelligence that may violate the consent decree. And that's very, very important to know. MPD does not escape coverage by the consent decree by virtue of working with other agencies.
Here, I'll just take one or two here. So
This note says, earlier monitoring team reports acknowledged that the quote-unquote Bob Smith account was not the only undercover account used or created in violation of the consent decree. What are the names of these other accounts? So I was looking for, I apologize for looking at my phone in the middle of the meeting, I was looking to see if I could find the specifics on this. The understanding I confirmed with the city that this is, you know, not non-public information, that they had also reached out to Facebook to find what those accounts were. There doesn't seem to be kind of an obvious answer to that question. It appears that Bob Smith was the one account that was kind of intentionally created by the city or created by the police department for the purpose of connecting undercover, but that the other ones, it's kind of unclear what exactly they were, but at least from all sort of information that we've seen, that those other ones weren't accounts that were created for the purpose of monitoring. Again, this is a little bit sort of third party, or third hand, maybe second hand, but certainly from the information that we've seen, including from Facebook itself, it doesn't appear that, certainly that anyone currently has the information on what those were, and that it appears that they might not have been created for the purpose of surveillance. And there are not known names that were associated with those. And then there was a question about whether the MPD's social media monitoring policy will be made public. Certainly, I think the intention and the work that we've done around creating a policy has been with the presumption that will be publicly available information.
And we're going to try, I know time is of the essence, so we're going to try to move swifter with answering the questions. A number of these, again, are somewhat duplicative, but who wants to go next?
I'm going to be quick. Are the police trained according to compliance and audit requirements? I'm sorry, are the police trained according to the compliance requirements? There's been a lot of effort gone into by the police department as well as the monitoring team and the ACLU to come up with appropriate training. That has not yet been implemented because the court has not yet approved it. Once approved, there will be a lot of training for the officers, both video type training as well as classroom training as it relates to political intelligence and so forth. Second question I have, can you describe ways that the MPD, given your audit and your reading of the McCullough ruling, has changed specific policies and practices since the ruling in order to comply with the order? It's all in flux. The police department is coming up with policies that will ultimately be approved by the court. I can tell you what Mr. Perry talked about with regard to situations that the police department asked for a ruling by the monitor. So that's since the ruling has occurred. Thank you.
Hi, everybody. The question I've got is, can MPD act on a tip from a citizen obtained by that citizen who got the tip from an internet chat room? That is a really interesting question. I will say that I can't answer that because that issue is currently before the court in the city's motion to modify the consent decree. That is a specific implication of the motion that is currently pending before the court. So once the court disposes of that motion, we will have an answer to that question.
Real quick, if an LPD officer is part of a multi-agency gang unit, OCU detail, and that detail is given orders or assignments that violates Kendrick, does the order or Kendrick prevail? Kendrick prevails. Number two, what would happen, what penalty is there for a law enforcement officer who does something that violates the decree, the consent decree, section J? Dissemination and posting of this decree says defendants and the city of Memphis shall familiarize each of its law enforcement personnel with the contents of this decree in the same manner in which those personnel are instructed about other rules of conduct governing such personnel. And so the implications are the employees are expected to know and understand what the consent decree says. It does not specify what punishment would be assessed. That is dependent upon the rules and policies of the police department. If employees violated, the department is in violation of the consent decree.
All right, this is a question. Can the sky cop cameras film innocent people walking and driving down the street? Does anything change in how they collect data by these cameras? And F2 addresses examples of that kind of conduct. F2 of the consent decree, and the standard that the police department goes by, is required to comply with, is that it says, this is what F2 of the consent decree says: the defendants in the city of Memphis shall not engage in any action for the purpose of or reasonably having the effect of deterring any person from exercising First Amendment rights. The question is, then in that context, with the use of sky cameras that incidentally film innocent conduct, would that reasonably have a deterring effect upon a person's exercise of their First Amendment rights, either when they're walking down the street or driving down the street? And that is going to be, if that question is submitted to the court, both the ACLU and the city have the opportunity to address whether that is reasonable under the circumstances to have that kind of filming of innocent conduct, and how long, if it is innocent conduct, how long the police department is entitled to retain that information and under what circumstances. But that's a matter for the court to ultimately address on the consent decree.
Okay, we're going to, I'll give a few more and then we'll open it up. I know that some of you want to have a question. I'm sorry?
Just to follow up. Section H of the consent decree also speaks to that issue. People are asking about how long information can be maintained. H1 says that information that's collected in violation of the consent decree must be destroyed. So that's a specific language of the consent decree.
There are a couple of, let me just deal with, and I mentioned this earlier, but I want to be clear. Question, will there be an opportunity for the community to be a member of the monitoring committee? I think I shared that, we've shared that with the board, and that has been, a number of these cards are consistent with what we presented to the court and what we heard throughout the first forum. Same question, you all say trust your word, but why is there no one on the community on the board? Again, I can't express strongly enough the focus groups. I know that's not someone on the board, but we welcome you. We want to get a cross-section of the community. That's one way. Again, this is commended to the court. So again, we wanted to put this is not just Ed Stanton saying, let me sing, we hear you, but this is something we've commended to the court. We're waiting to get direction from Judge McCullough with regard to that request. We have a number of questions, and I'll turn it over, open it up for questions. But a number of these cards fall along the lines, and I'll just read one. Does the monitor think the city is in violation of Judge McCullough's rulings by its PR campaign and scare tactics that the consent order hinders MPD legitimate law enforcement? Does the monitoring team have any plans to publicly address and take a stance on the distribution of disinformation by Mayor Strickland, in particular to narrative? And so there are a number of these cards. Let me be clear, and one of the things that if you look at the packet of information that we've shared, our role is to enforce and ensure compliance with the consent decree. I will say this, the city has made clear, and I'm not saying anything that hasn't been made public by the city, their position on what they believe the consent decree and how it hinders them to do their jobs from a law enforcement and public safety standpoint. You've seen that in the public, and that is, the bottom line is that is what's being considered by the court. That's a position that the city has taken since trial last year, obviously in sealed documents that I can't go into. And so the final arbiter to answer those questions it is outside of the scope and purview of our role to get in front of Judge McCullough and make a ruling on whether or not the city is violating or using scare tactics, and I'm just using some of the quotes I've seen, PR campaigns. We are not in a position to call balls and strikes. That is certainly Judge McCullough, and anyone that knows him knows that he has no problem making a ruling and making it clear his position. So again, we will do our best to get all of these other questions. Again, many of these are somewhat redundant, so we won't go through all of those, but those others we will put on our website, questions and answers. I saw one hand here, and then a gentleman in the back. We'll go there. I saw another gentleman. And again, we would ask if you could make your questions very concise, and we can try to get as many as possible. Yes, ma'am.
What you just said raised a question for me in addition to one I'd already submitted to you in writing. So that is, will the judge make a decision with or without our input, or is only the city input and only ACLU input? Or do we get a chance to give an input on the issue of whether this should be considered dangerous to conducting public safety issues?
Good question. I think one of the things that Judge McCullough mentioned is that we, as the monitoring team, are the eyes and ears, if you will, of the court. And so, again, we welcome your comments. We welcome you to reach out to us. We share, and a lot of times, many individuals that we've met will say, I'd rather remain anonymous. Others have said, you can use my name. So two things I would recommend. If you have information, you can share that with us, and we will make sure that that's incorporated as we share sentiments of the community with the court. I would also recommend on the 21st, 2 weeks from today, to show up in court. Those of you all that were at the last court hearing, Judge McCullough had each individual that was willing to stand up and share who they were and what they wanted to say, and gave them an opportunity to do exactly what Jackson that you were mentioning, and that is hearing from directly, getting your words or your thoughts to the court. So I saw another that yes, sir.
I came here the first perform y'all had. It's like the same thing. Everything that's in action is no answers to it. I'm not for sure who else, but I know I'm pushing the community, and I see a couple more faces I'm familiar with that push and apply pressure and hold these police accountable for the wrongdoing of others. And I don't know if y'all know it or not, but hey, it ain't no walk in the park. So really, what is this meeting for? Like, if y'all can't answer the questions that need to be answered, what are y'all doing? And the most important part of that question need to be answered. Why is there no one from the community on that board? Y'all saying trust y'all and do this and do that, but when we come to y'all with the questions, it don't get answered. So if the shoe was on the other feet, how would you feel? Do you know what it's like to be followed, try to be intimidated when you know you ain't gonna give up and you constantly apply pressure? Hey, that ain't no walk in the park. I don't know if you don't know me, but I'm Cassio Montez, Google it. And I'm out here doing the work. So we need answers. Like, this is like the Fury situation, man. I don't have time to come down here every time thinking that things gonna change and we get the same results. That's insanity. Doing the same thing over, thinking you're gonna get different results. So I don't know what y'all about, but hey, man, y'all need to get it together.
Y'all have a blessed day.
I'm gonna let you answer this question, then I'm gonna ask you.
Simple.
And I will say this, sir. You're welcome to come and meet with me and the team and share as I shared that at the last meeting, and the floor is open. And I want to know what question didn't get answered. Which question specifically were you referring to?
Why is it the main concern? Why is it no one from the community that pushed just like I pushed against the wrongdoing of others from the Richmond Police Department on this committee?
And sir, I will tell you that was the first thing, the question that you're asking. We posed it to the court. We can't make that call. I can't appoint anyone to this committee. That's Judge McCullough. That's a federal judge's purview, sir. And what I'm trying to explain to you, the first thing that we told the court, we have about a dozen things that we learned from the first meeting that you attended. And the first thing, and I read that, Judge McCullough, there are individuals in this community that they don't have trust because there's not someone from the community, a layperson, not law enforcement, not lawyers, not enforcement individuals. And that's why I wanted this to be in the, because I figured this would come up and I wanted this to be in the packet. I'm not making, this was filed with the court. This was those of you that were in court,
in August, I shared that with the court. I can't make the court move any faster or do anything outside of what's in his direction, sir. And so when you say we don't do anything, I think we did. We did everything we can. We can't appoint anyone to this committee. I'm done.
I'm here to understand the person.
Yes, sir.
But you can't continue to come and go have a meeting, but you still give me the same answer. This is the first, like you just said, before you reached the mic around, you just said that was one of the main questions that was asked the first time. So we come right back around and give the same answer again. What's going to be the next time? I could be out there trying to do what I do best, push.
What I can tell you, sir, is we listen. I think there's a reason why you have a number more people here. People complain. You have a blessed day as well, sir. Yes, sir.
Yeah, my question is, Samuel Hardeman, Commercial Appeal, wrote in quote, before the Memphis municipality election, Strickland administration filed documents under the seal in federal court asking to modify the 1978 Kendrick consent decree in court. In question, are you all aware of the request and what is the status of it?
I'm sorry, what's the status of it?
Yeah, I mentioned that earlier, and maybe you missed it, but
I didn't get it.
Okay, sure. That was about 4 or 5 things I said that's what's coming up next. And we anticipate the court will make, again, he doesn't tell us when he's going to make a ruling. That was briefed. He obviously gave the city an opportunity to file the motion. The ACLU had an opportunity to respond, and there was back and forth. All of this is under seal, so only the attorneys, the parties, and the judge knows. But we think that there very well could be in the upcoming weeks or near future that the judge will rule on that. What's the status?
Are y'all aware of that?
Are we aware of? Yes. Yes. Yes, sir. Good question. Yes, ma'am.
Thank you for handling this earlier. So I heard you guys say that y'all are working on policies and procedures for a lot of the stuff that's in flux. What I'm not clear on are you guys also able to submit policies around the actual penalties or consequences of violation? And if not, who would be the person able to actually push forward finite penalties or consequences for violation of the decree?
Yeah, we don't get to say what the penalties are, but we have been able to propose. We have submitted, I think we told you all, an audit and compliance plan, and so that should have the kinds of benchmarks that you're talking about. We can say, are they doing what they're supposed to do, and if not, here's the consequences. So we have submitted that to the court. We have to get the court's approval before. Once that's implemented, once that's approved, we can start implementing.
How did y'all come to make a determination of what the consequences would be? What that mean?
Well, it hasn't been without you all. We've been we had this meeting in July, and we've been having individual meetings to inform the things that we send to the court. That's one of the things that Mr. Stevens was pointing out, that bullet list of 12 things, those are all recommendations that came from the community. Those are not recommendations.
How do we get to have those community meetings with you? We were not aware that that was an option. So how do we have those?
And I am specifically saying that I get that the format of the monitoring meetings and that, but I'm saying specifically the consequences of violation of the decree. How were those informed?
That's totally coming from the court. So the court can design and implement whatever punishments he thinks are appropriate.
Okay.
So like the sanctions order that we looked at, those are things that the court determined were the appropriate things.
But I think to answer your question,
You said you wasn't aware. Call us. Call us. And I mentioned earlier, there's not been one individual that has said, I want to share. We've had people who feel like their rights are still being violated. The consent decree is being violated. I have tips on if you really want to have a meaningful meeting, a community forum, because what you did the last time was terrible. And again, share with us. My point is, if you call, if you email, that is the best way for us. And again, we won't say, well, we don't have time. We will, again, that's part of what the court is asking. So we welcome that input and we take it seriously.
And just for folks who didn't see, in your packets is this sheet that has contact information. So you can use any of these to reach out.
Yes, sir.
Thank you. I asked this question in our group, but many of us were affected by election and dissemination of that information. I want to know, will there be a policy or policies developed for the retrieval and destruction of that committee, of that process. Because they disseminated that information to the Memphis Tomorrow Consortium, that for no reason, they didn't need any of that information on us. And I'm concerned about what are they doing with that information. What's St. Jude, FedEx, AutoZone, why do they have information on me? And are they gonna give it back?
Yes, sir. So,
Yeah, give them that mic, and you got a green mic on the end there.
It's, okay. Yeah, so Section H of the consent decree addresses that directly. And it says that any information collected in violation of the consent decree must be destroyed. And so there are specific policies that we've been working on with the city in conjunction with the ACLU for how information comes in and how long that information can be maintained. If it's determined that it was gathered in a way that is not consistent with the consent decree, how long it can stay there before it must be destroyed. But it must be destroyed if it was gathered in a way that violates consent.
There's a book now.
Mine is just a follow-up to Al's question. So I'm assuming that you all then have jurisdiction over companies who were given illegal political surveillance information. You don't? Okay, thank you.
So what's to be done? What about these third parties who receive this
Information.
gathered information?
They can't get rid of it. If they already have it, they can transfer it to a different file. And always destroy the other file that they have.
They're called JIBs.
So I'm asking it to.
Yes. They were sent to non-governmental agencies, non-enforcement agencies.
Yeah, the Joint Intelligence Briefing.
Right.
Yeah, that's one of the big things that the court said that the MPD can't do. To address your specific question, we don't have jurisdiction over the third parties who received that information. We do have some, it is within the monitoring team's purview to say to the city, you can't keep this information and you can't share it. If the city doesn't like that answer, they can appeal to the court. But we don't, as far as I'm aware, we don't have a way of going to say AutoZone or to St. Jude and saying, hey, cough up all of the information that you never should have gotten in the first place.
But this, I guess, early part of that question, one thing that we have done, and that is recommended to the court, we're hopeful at some point the court will make that public, our recommendations. And so a lot of the processes, we're changing policy on procedures, retention, destruction of information and data. Obviously, we consulted with, we shared what our thoughts were, the best practices with the city. We allowed the ACLU to weigh in. And so hopefully you'll be able to see that in the past the court has put that and made that public. And we have it on our website where you can see what we've recommended as it relates to retention, destruction policy, what you can keep, how long you can keep it. I mean, again, there was what I wanted the details to push back as far as how long MPD may think that they need information. We had an opinion, the ACLU was able to weigh in, but I'm hopeful at some point, we've shared that with the court in our last report, and that part has not been disseminated, but that is a part of what we have been able to weigh in on. Yes, ma'am.
So one of my big concerns, and I think other people, is in the sanctions, it specifically says while the officers are on duty. And that's a big problem because much happens when the officers are off duty. So what's the formal process that we should go through to, like, maybe make sure that the ACLU addresses modifying that?
Ms. Costello, you want to respond?
They're never, as an MPD officer, they're never off duty. I have several in my family. So even when they're on duty, they're never off duty. They have to carry their gun in their badge anywhere they go. So they're typically, when they're off the clock, they're still on the clock.
And you're absolutely right, sir. Because an officer, and this applies to any department in the United States, and should. If an officer goes home and takes his badge off or whatever, that officer is not now free from the restrictions and the requirements of his or her department. An officer who is subject to consent decree cannot, under the pretext of being off duty, do things, collect evidence unconstitutionally, collect political intelligence that he or she cannot do when they're on duty, and that's absolutely correct.
They're doing it now.
Well, and let me say this. Let me say this, and this is very, very important. How do you figure out? How do we determine? How do we make sure that they don't? First of all, we're in the process of developing, as part of this process, the interactive process, we are developing policies and procedures right now that include things like requiring officers to document if they're using, let's say, under certain circumstances, a personal communication device. Even that is going to be regulated. We've built an audit and compliance plan. What does that mean? That means that this team and people associated with this team can go in at any time without any type of prior notice, a minimum of a certain number of times a year, what have you, but more than that, and get access to any records that we need in order to ensure that the consent decree is being complied with, and that, for instance, evidence or information is not being unlawfully collected in violation of the consent decree, and things like that.
Yeah, and let me just say this, you said it's happening. We'd like to hear that. We'd like, if you would mind sharing the information that you have so we can, yes. Someone, yes, sir.
Do we as the public know what information was shared with the private entities? Has that been released? Has that been disseminated?
Some of that information is in the court's orders. If you, it's court, so all of the documents that are filed with the court have a number called an ECF number. If you look at ECF number 151, it identifies some of the information that was shared with third parties.
And the actual third party. Yes, ma'am.
Mr. Stanton, question about the third
Yes,
party
sir.
information. As a former U.S. prosecutor, if I received ill-gotten goods, would I not be responsible for any crime? So if another private entity received improper political surveillance, shouldn't they also be held under the same jurisdiction? Right? I mean, for example, if U.S. prosecutor, you're about to break up a car smuggling ring, I received a car, I'm partly responsible because I received ill-gotten goods. If they received intelligence, political surveillance that was illegal, as decried by the judge, should they not be held responsible as part of that?
Well, that's a good question, Greg. I think a couple of things. One, you have to see whether or not, in this case, the statute, or in this case, the consent decree applies to those individuals. Now, Section I believe, says, and it goes back to basically where you can't have the police department getting cute. Hey, we can't do it, but we can, you can, and this organization or this legal entity or law enforcement entity can. But as far as holding someone else accountable, it goes back to almost what Mr. Perry just said, as far as destruction of documents. There is nothing outside of a court order or if there is a statute in place. What's unique here is that the consent decree only applies to the city and its divisions. And so it doesn't apply to, let's say, somebody mentioned AutoZone or FedEx or St. Jude. So it is not as clear cut. It would have to be a violation of the state. If I'm looking at this from a prosecutorial lens, I'm looking at the statute, who it applies to, and the requisites to violate the statute. And what you just laid out, I'm not sure that, certainly from the city's end, there's culpability or should be responsibility, but it depends, I will just say that.
So what about the crime commission who may have elected officials who are part of the board?
I'm sorry, say that again?
The crime commission who may have elected officials or police officers or top rank who are part of their board or director. What about that? The crime commission.
I'm familiar with the crime commission. What's the question?
What about elected officials who's possibly on their board or top rank officers who's possibly on their board? Because they get funding from the crime commission to do sorts of things like they do.
that they're sharing that information with the crime.
The same way they get funding from all those organizations to do this.
Yeah. You gotta bust on the crime.
That's not what I'm saying. What I'm saying is, the consent decree prohibits the police from using anyone else, the crime commission, or any other third party from doing things that the police can't do themselves.
One more. So how would the police be tied? If we all went out here protesting right now, what can the police can and cannot do to us? Because during our protests, they've been known to video and suppress and harass, infiltrate, push, shove, hit people with cars, drag people.
Yeah, I mean, some of that, and I don't mean to be flippant, right? No, the police can't run over you with their cars. Right, yeah, no, I'm not saying that those things have never happened, right? What I'm saying is that there are legal remedies for those kinds of behaviors, right? That's all I'm saying, right? And so, right, I mean, this lawsuit, right, sue, right? Which is what the ACLU did, which is what Mr. Franklin did, right?
So we have to sue for them to not do what they shouldn't do.
I would say, let me say that. Let me say this, and going back to Mr. Coy's point, as a former federal prosecutor who prosecuted a number of Memphis Police Department officers as well as law enforcement, we had something called the Tarnished Badge Task Force, and so I'm familiar with them. And I want to be clear, there are bad apples in every group, but those bad apples, so not only lawsuit, but federal prosecution. Those were the individuals that as U.S. Attorney, I wanted to hear from. Those individuals that are violating the rights. Going back to Mr. Franklin's question, though, what can't they do? I knew that question would come up. I would welcome you to go back. There's literally a short guide to the Kendrick Consent Decree that is in the second part of Session 1. And there is a section that says what the Consent Decree prohibits. And so you'll see there's an item. So, for instance, if the police department, they're intimidating, if they are disparaging, discrediting, if they are acting in that type of manner from a political intelligence as it relates to your First Amendment rights, that's a violation. That they can't intimidate you and say, hey, we're going to have a chilling effect on your First Amendment rights. If you want to speak out because of the group or because of your police or your First Amendment rights, that is in violation. Those are the types of things we want to hear. We do have the purview to hear that, share that with the court, and we can say, Your Honor, the police department or this officer, whatever the case may be, is out of compliance. The consent decree says this, so I would welcome you again. I know we don't have the time, but great question of we have just a two-pager of what the consent decree says you can't do or the city or the police department can't do. I want to get
And I know you said we don't have time. Can we make a community agreement? Do people have to leave right now? Do you want to stay and listen to what they say?
Yes.
Okay,
so we have made time, but we'll continue to do. We do want to be mindful of. But Mr. Cross said he could give us a few more minutes. He's a manager here, so we're fine. Again, we want to get to as many questions as possible. You all have come out on a cold evening, and so, again, we'll keep going. Yes, ma'am.
Wait, while I still have the mic, I'd like to
I'm sorry. Yes, ma'am.
I'd like to get some clarity on the status of the destruction of the information that was collected. It sounds like because the negotiations are still going back and forth, that this information has not been destroyed, or that you're aware that it has been destroyed. What is the actual status of that?
Yeah, I would, I don't know if we have any other, that is not something that the court has entrusted us to deal with, the dissemination or the destruction of documents. I'm assuming those things that came out of trial is what you're referring to?
All of it, what came out and what didn't come out, is the whole collection of this illegal information. Has it been destroyed or not?
They already said it's in the trunk.
Honestly, I do not, that has not been presented to us. If that is something that you want us to share with the court to get some answers, we're happy to do that. But I will always shoot straight with you when I can tell you I don't know the answer to that question. I don't. We have not been charged with dealing with, and we have heard in some of the meetings that we've had, that same question has come up. What about, in fact, there have been individuals who said there's information that's dealing with me that we've heard. Where do they go? Is it still pending? Is it with a third party? That has not been something we've been instructed to do by the court, but we will share those sentiments and maybe we'll get a response as to next steps. I'm sorry, yes, ma'am.
I have two questions, and I can keep it brief. But one, is the use of the Stingray technology in direct violation of the consent decree? And like, you don't have to go into a long explanation, yes or no?
Lawyer answer on that one, maybe, right?
Maybe. Because it does suppress and it does prohibit the act of our First Amendment right.
Yeah,
So,
maybe, right? Here's a short way to answer that, right? There are things that if they are properly authorized, can be legal, that would not be legal outside of a certain set of narrow parameters, right? So there may be a circumstance where it's okay to use Stingray, and there may be a whole wide set of circumstances where it's not okay to use Stingray. That's not a question that we can answer in the abstract. It would have to be, is the use of Stingray.
well, is that a conversation that's being had about that technology specifically?
That specific technology is the subject of the discussion that we can have.
Okay, and then my next question is, who is the final say-so and the determinant of what is considered political versus criminal?
So the consent decree defines political intelligence. As for when a thing becomes criminal, right, there are legal standards for that. Parties can argue about that, but the court makes a ruling about whether a particular thing in a given case is criminal, and if so, what kinds of safeguards should be in place.
Okay, so if they're anticipating a protest, they're going to say, okay, well, we're anticipating criminal activity, and then they have to go, I guess, to you guys and say, can we do this? Are they proactively just standing down, or are they going to go ahead and gear up under the pretense and the understanding that there's criminal activity happening?
Yeah.
They'll do exactly what you said.
Yeah, that's a great question. As Superior was saying, they'll do exactly that, and that is one of the things we have been doing. Maybe that, I'm not sure if it was in the small group sessions, but real-time authorization. So to your point, hey, there's a parade, there's a rally, there's this, there's that. Can we do that? I mean, that is part of what the court has instructed, and the court has said, you monitor team, Mr. Monitor, you have authority. They don't have to keep coming to me for this. They need to go to you for authority. So I can tell you, I've had requests as late as after midnight. I've had requests, I had to make a call, real-time call on certain requests, other items that they knew that were coming in advance that potentially, and so I will say that there's a number of times that we requested more information, just to say, hey, this is not enough, and for you to have authorization to proceed in the manner that you're requesting. And so that is a part of what we've been doing, real-time responses to the city's requests, and that is something that we do have the authority. The court has given us that authority, as he called us, a special master to handle those types of requests from the city. And so they are doing that, as opposed to just putting their hands in their pockets and say, we're not doing anything. We've received a number of those requests. I'll come back, but I want to make sure we get to some individuals we have not heard from. Gentleman on the second row there.
Thank you. I'm Adam from Micah. We were told by the city this week that this decree poses an obstacle to public safety. I've been listening to your explanations and I cannot figure any way in which you would possibly do that. In fact, as far as I can tell, it will make the public more vulnerable to harassment and abuse by the city. And I'm a Christian, and in my Bible, the prophets were called dangerous by their governments too.
Hey.
So, but this is a democracy. So my question is, what can you explain how, if it's even possible, for this decree to be a threat to public safety?
Yeah, and I think you're asking, sir, thank you for your question. I think you're asking us to make the argument for the city. And that is something that we're not in a position to, and quite frankly, make the argument for the city or the ACLU. This will be taken up by the court. These are some of the arguments or positions, I should say, that the city has taken are very similar, if not identical, to what they had during the trial. So some of this is not unique. Obviously, there's been a filing by the court, a response by the ACLU that's under seal that we can't go into. But otherwise, I would take off my independent cap by saying, hey, city, you're absolutely right. Or ACLU, you're wrong, or taking a position. Now, I will say this, when, until, or unless the court, if the court calls upon me and the monitoring team to give a response, in our opinion, we're ready to do that. But we would be outside of our bounds getting in front of the court knowing there's a pending motion. So I hope that answers your question. Yes, sir.
Are you going to investigate MPD's use of authorization of agency, which is Strickland's way of issuing restraining orders without judicial?
That was one of the things that we heard on a consistent basis, as you may know from the first meeting, in our follow-up 101s with individuals. I will say that we have addressed those on a case-by-case basis. When you say investigate, certainly, again, I go back to if you are aware that AOAs are being abused or in any way encroaching upon the mandates of the consent decree, we want to hear about it. And let me just say this. Let me just say this, sir. And so we have had circumstances where citizens like yourselves have called us or reported us what they thought was a violation. We've been able to get with the city and pose questions, and actually the court has said not only you get with the city, but we want to make sure that the ACLU is a part. He wants to make sure that the ACLU is part of that conversation. And so we look at those on a case-by-case basis. When you say investigate globally, that's not necessarily our job, but if we're made aware that, again, that these AOAs are being used in violation or out of the context under the purview of the consent decree, we have been responsive.
Is the monitoring team going to, sorry, I'm over here. Hi. Is the monitoring team going to continue to hold informative meetings as the court's rulings come down on these issues like training, compliance, plans? Because I think a lot of the lack of trust here comes from people are asking serious questions, and the answer, I know it's not your fault, but the answer is, well, it's up to the court. Well, we're waiting on the court. Well, we're waiting for a court decision. So will you continue to hold meetings like this as these rulings come down?
Yes, and we welcome your input of how we can make these meetings more meaningful. We're hoping that this meeting is at least somewhat more meaningful with the information that we shared in the format that we, again, recruited from or adopted from recommendations. But yes, we are planning every quarter to have meetings, and until and unless the court tells us to stop, yes.
Okay, I have two questions. There are several things that you've mentioned are under seal or you simply cannot or will not answer. So is any of this information available to law enforcement officials or elected officials, whether they be things that are under seal or potential violations? That's the first question.
Those items that are under seal are for the parties and the council's eyes only. And so no one, whether elected officials or certain members of the community, should not be able to view or review those documents. And if they do, they run subject to run afoul of the court's orders and again, face severe consequences. So no, under seal means what it means. It's under seal in very limited eyes, in this case, counsel for the parties.
And my second question is, have any members of the monitoring team previously been connected to or affiliated with any members of local law enforcement or elected officials?
And I think I saw that question on one of the cards. So I mentioned earlier in our introductions, I know one person, Dave McGriff, is a former police officer, he was a career law enforcement from Washington, D.C. He started his career here and was a Memphis Police Department officer for how many years?
3 years, and I left in 1976.
3 years, 1976. And I will tell you, as a part of why he is and was appointed to head up the audit and compliance section or expert for this group, is I wanted someone who's been on the inside, someone who knows what to look for, the blind spots, because we want to make sure that this has some teeth and that this is not just a perfunctory lap of we check the box and go back to business as usual. So someone who's actually worked. So to answer your question, yes.
That makes transparency very questionable. The problem is that there are people on the inside who continue to violate these things, and then they're continuously protected by this thing called the blue wall or other elected officials. So that's why we question where relationships lie, especially when we can't get any answers to questions.
Okay. Well, as it relates to transparency, I think during the introductions, I mentioned Mr. McGriff's background. I will tell you, you have a former police chief here who is not part of the Blue Wall and who is nationally renowned. I think we've all heard of what happened in Baltimore and New Orleans, as well as Chicago. Dr. and across the country, but this gentleman here, this former police chief here has been recruited to serve on those consent decree monitoring teams. I'll let Dr. Bowman speak for himself.
Sure. I'm not willing to put my international reputation on the line to cover up for anybody. So I'm here on the team, and I call it like I see it. And I don't have a relationship and didn't have a previous relationship with anybody here at the Memphis PD. But all of us are professional, and I can assure you that I'm not compromised in any way, and not willing to compromise my integrity in any way.
In full disclosure, I mentioned, some of you may know, I was a former U.S. attorney, so I'm literally the chief federal law enforcement officer there, not only local, state, and local, but federal, FBI, all the agency heads reported under my watch. And so again, I worked alongside with joint task forces when I was a U.S. attorney, but at the same time, I headed what we call tarnished badge task force. It wasn't just Memphis police officers, there were Shelby County sheriff's officers, deputy jailers, and the like across. There was actually a model across the country of another one of the U.S. attorneys saying, what are you guys doing in Memphis? Because there typically is a rule. So how can you prosecute and indict so many law enforcement members of the community when it's so tough to get past that blue wall? So I'm proud of the work that we did there. But yes, that was my previous affiliation. Again, if you go on our website, you will see our backgrounds, and transparency is important. So I appreciate your question. Yes, sir.
So I know that the policy isn't outlined for social media use yet, but once again, I feel like I'm continually being intimidated by the Memphis Police Department, the multi-agency gang unit in particular. And so, I mean, right here on my phone on September 20th, an officer, Stephen Grigsby, with the multi-agency gang force, I get a notification that he's followed me on Facebook. So do they have a stand down order in the meantime until y'all get this worked out, or is it business as usual for them? Because it does have a chilling effect on me personally, and it showed on everybody. Because I don't feel like anything's changed in those regards. So, and would that directly violate the consent decree right now, would you say?
The question is, if an officer friends you on Facebook, does that violate the consent decree? I mean, if you can make out that it constitutes harassment, you know, if we can establish that,
What?
Because harassment is specifically prohibited by the consent decree,
Right.
maybe.
So every time I've been arrested in the city at a rally or a march, it's been by the multi-agency gang unit. In court, an officer explicitly said that he had orders from his superior to arrest me no matter what I was doing. And it's always these multi-agency gang unit officers that follow me or sit outside my house.
How many times has that happened? They've been sitting outside. You got it on video. God.
In 1 month, I think it was 20 times.
Yes.
Pictures and.
We're talking about some repercussions. This is ridiculous. Violations.
How has that happened still? Why? Why has nothing been done about it?
Policing the police.
Yeah, okay, so why are police parking outside of people's houses? Right, that could be different for each occasion that they're there, right? We have to be, you've got to bring that to us when it happens so that we can assess things on a case-by-case basis. There's no blanket way for us to say, if the police show up on street X, they are violating the consent decree. There's no way to do that.
So has he not been bringing it to y'all's attention? Because, I mean, what I understand he has.
If it's okay with Hunter for us to say, we have met with Hunter, and when he brings specific things to our attention, when other citizens have done that, we have reviewed them, where we have found those things to be suspect under the consent decree, we have raised them with the city and with the court. I hope that answers your question.
It's gotten worse.
No, because what happened once you did? Once you brought it to the attention of the city and the court, what's happened?
Well, so one of the things that happened is that the city has now asked that the consent decree be modified.
Okay, so what should we be doing to show that we don't want it modified?
Well, so the ACLU has responded in opposition to that motion.
But as we as citizens, what can we do?
We just have a legend. Fuck that up. Well, for one thing, you can do what Mr. Chan did. You can come to the court hearing, and you can express your views to the court. The next hearing is on the 21st of this month. At the last hearing, Judge McCullough asked community members who were present to submit statements directly to the court. Several community members did that. One community member submitted a video statement. So it seems to me that the court is looking for ways to get information directly from citizens.
Yeah.
Not just through.
And if I may add, Mr. Castelli, your phone is always open, right? I mean, and you take those calls. I mean, you were the counsel that actually sued the city and said, hey, you guys are violating this, and that people shared information with you. But I just want to make sure I'm not misspeaking that your phone is always open and your line is always open for.
Well, not literally my phone. Please get in touch with the ACLU. Some of what I'm hearing are. Some of the things that I mean, again, talking stuff at the ACLU, some of the things, I think it's important to understand, this decree is not encompass the entire Constitution. It puts on the city certain things that are greater protections in the Constitution, but some of the questions I'm hearing asked, there may be individual constitutional violations that are being described, and if there's proof of them, there may be other ways to address that this monitoring team cannot, and that this lawsuit that we brought are not designed to address. That doesn't mean they can't be addressed. And so if someone thinks that their constitutional rights have been violated, you can reach out to us. I'm not going to tell you 100% I can take your case, because some of it depends on what evidence there is of it. And that's, every individual case is different, but you can go on our website and fill out our intake form. You can email intake@aclu-tn.org and describe what's going on, and those are two ways you can reach out to us about some of these issues. Some of the things that they have to do with the decree, I may then forward on to Mr. Stan and the monitoring team and ask them to look into it and pass it along to the court as well.
Thank you. We have gone nearly.
On Labor Day.
And let me just say, I'm sorry, I'll let you speak. We may have time for maybe one more. We've gone about an hour over, and we'll do our best to get to these minutes. I'm sorry, and I'm saying that just because the staff had mentioned that they are, so we have a few more minutes, but go ahead. I know Reverend Love has had her hand up for a while, and you've already, I know, to make it real quick.
You allowed people to questions, and I thought the other one was because of the statement you made, with all due respect. On Labor Day this year, once again, and in the past, I have actually been held at gunpoint along with about 15 other people by police, based on information that was not necessarily correct. So this concerns me that I encountered an excuse and what I believe was an attempt for intimidation by police on Labor Day this year, with their refusal to escort the Labor Day annual march from AFSCME down Beale Street unless we took off or covered up any political t-shirts and removed any political signs. They really wanted us not to march. They were attempting to intimidate us. But when we said we have First Amendment rights to march with the permit that we had secured, they rode off and left us claiming their orders from the top. They said from the top, said that they could not escort a march with political apparel or signs due to the consent decree.
That's right.
So later they apologized, but they were operating under direct orders from the top. Should this confusion be happening, leaving Memphis residents unprotected while marching in a permitted march? Should we constantly hear messages confusing protection of First Amendment rights and other constitutional rights with public safety issues regarding criminal investigations? I'm also from Micah, and that was also what Adam had raised earlier. As I said, I obviously was one of the John Does when the police surrounded our house, about a dozen of them with a horseshoe-shaped set of rifles pointed at our house. And I was with my 3- and 5-year-old daughters at the time. We had about 6 or more children under the age of 8 with us, and there are maybe about 15 of us all together. So I take police surveillance and threats seriously. I also take seriously their lack of willingness to protect us when we're marching.
Yeah, and I'm glad you brought that up. The Labor Day parade, you're absolutely right. And no, that should, to answer your question, you had a question as a part of that comment, and you said, should this be happening? And the answer is no. I will tell you, because we had citizens to make us aware of what happened and know exactly what you're talking about, that was something we didn't believe was in our purview, and we acted on that. We also...
Is there a penalty that they receive because of that?
I cannot get, well, let me just say this, the way the process worked. We reached out to the city to say, hey, there's been complaints, and we wanted a response from the city. We were also instructed, going forward, we reached out to Ms. Costelli as well, but the court wanted to make sure, don't just reach out to the city, make sure that the ACLU council, or that they're made aware of this. And so we have had a response, and we've shared this with counsel for the ACLU. The court is well aware of the incident, and obviously the city had a response. At some point, maybe that can be made, again, it's up to the judge to what he allows to be made public, but that's a great example of sharing with us. I mean, we will tell you, obviously, if it's something that we cannot address, if it's something like Mr. Caselli said that's outside of what we're charged with doing, but it still may violate, I mean, a number of these things that I'm hearing, again, the tarnished badge task force is still, as far as I know, is still in place, and a number of these items sound like civil rights, federal violations of civil rights statutes that we prosecute. I used to prosecute in my office quite frequently. So that's a great example of, in my estimation, the system working. You want to know what happened and how it was adjudicated. Again, the judge will hopefully make that public, but that was something that was brought to us from a citizen or citizens, and I think we acted appropriately. I'm sorry, is there, I think there was one other hand, and I'll give with you. Okay.
That's okay. Can you use the mic? Can everybody hear me?
And if we can make it very brief, I know that staff here.
Do audits include police personal social media accounts and use?
I'll let the audit and compliance person answer that. But at this point, what I can tell you that it does, the use of MPD distributed phones and media, things of that nature, that is what, so are you saying, can we go to someone's house or use their personal cell phone and audit it and compliance? If that's what you're asking, no.
I'm saying, can you audit a police officer's social media accounts?
Yeah, and
we
What we
drafted.
heard earlier was that police are on or off duty, police are always on duty. So can you monitor police social media accounts, and if you can, are you?
yeah.
What we've proposed in the auditing plan is we've asked the court to make sure that the police can't do anything via their personal accounts that they couldn't do via
Yeah,
their.
cool. I think that's been an issue. Can this body use its power to enforce body cams, police using their body cams at all times? Because we know that police officers turn their body cams off, and that's when a lot of violations happen. Whether it's them killing young black people, or whether it's them harassing people or arresting them under charges that they say happened, that the people that it happened to didn't happen. Can this body use its power to try to force police officers to maintain their body cams?
We have had several questions, real-time requests from the city about the use of cameras, body cams, and otherwise. We've answered those questions, and some of those are before the court now.
And we're also on the footage.
I was going to say, that is where you all can play a part, and I've said it a number of times, but the focus groups, that is one of the areas that we want to hear from the community, because depending on who you ask, you have some people say, we think body cams are a great thing, or sky cams. We have others that say, to your point, there's some very, very serious concerns. So that is a part of the focus groups, and you all play a part of the process. But we have made a recommendation. Hopefully the court will make that public, and our recommendation to the city as it relates to body cams.
Great. And is there space in this body for reparations for people who have been affected by the violations of the consent decree? I mean, there's hundreds of names, hundreds of people on the list, a lot of people lost jobs. I mean, this information
And what you're suggesting sounds like sanctions, and only the court can admonish or give the sanctions. We provided a list of the sanctions thus far that the court has issued.
I mean, there's things that have already happened, though. You know, there was, this feels like an ongoing thing, so there's things that that have already happened. There are people who testified in court. We know some of the people who, like, brought this lawsuit forward. I don't know if monetary reparations were made for them, but I feel like there are a lot of people who were very negatively and economically affected in this situation, and Memphis has one of the highest poverty rates in the entire country, you know, like, I really think that the city needs to make reparations, monetary reparations to the people who lost their jobs. I know people personally who lost their jobs because they were blacklisted from City Hall, or people who didn't get jobs because of the jibs that were given out. And like, before that's destroyed, I want the people whose names were affected by that to, like, I mean, their whole lives have been impacted by that, and I want something for them. So is that a focus group that I need to join or start, or like what? What is that?
Yeah. Let me just say, again, those are sanctionable. When you're talking about reparations and monetary, we can't sanction, that's not our, if the court tells us to do that or wants recommendations of how to do that, we're happy to do that. But at this point, as of today, that is outside of what we have authority to do.
So that's not something that you can put in your commends that you give to the court that came out of the...
Sure. I mean, and again, there are a number of things that we share with the court, and that's again, we're happy to hear from you, and if that's something that you want to be shared with the court, absolutely. And I welcome you to come. I invite you again on the 21st. The court, you may be able to tell the court directly in open court, or you may do the same thing you did back in August and say, hey, I want to hear from you. Get your information to the monitoring team. Listen, I want to thank you all so much again for coming out. I want to thank Mississippi Boulevard and the staff here, our monitoring team members. I know it's a cold Thursday night for you to come out and share your sentiments and listen. We appreciate it. We will keep you posted. We plan to do this again for the next quarter. In the meantime, please go to our website, share information, receive information, and those of you that can make it on the 21st, Judge McCauley's on the 9th floor of the Federal Building, 167 North Main. Please attend. Thank you.